What is an affirmative defense when it comes to a lawsuit or a criminal case? I'm Kevin Kneupper. I'm an attorney at Kneupper and Covey, and I want to explain to y'all what this is and what it means and why you want to know about it. So, an affirmative defense in general is a defense to either a civil lawsuit, which is where two people are suing each other in private, or to a criminal case. They use the term for both of them. And I'll give you a quick example if you just want like the very high level of what this is from criminal cases that we all know about. We've all heard about like murders, right? So, um, in any criminal or civil case, there is something called elements. For a murder, like let's say it's a first degree murder, you have to prove that it was done in cold blood. Basically, that the person who did the murder, thought about it, they had time to plan it, they like did it on purpose. So that's something that the prosecutor has to prove in order to win their case. So one way to do just a regular defense would be to say, I didn't do it in cold blood. Like I didn't plan this. I ran into someone with my car, but it was an accident or whatever. Then it would be manslaughter, not murder, because you sort of beat back one of the elements of the actual of a murder of a first degree murder. It's one of the things. There's others that you have to check, but there's just a checklist of things you have to prove. One of them is in cold blood. If you didn't do it in cold blood, you win if you're the defendant, at least on that charge. But another way you can win or defend against something, it could be a criminal case or it could be a civil case, would be to use an affirmative defense. An affirmative defense is something that it's a defense where it negates the entire crime or civil claim against you, regardless of whether the prosecution in this example wins everything. So let's say they showed that you actually did intentionally kill someone. You did have time to think about it. You did, like, it was a conscious decision. It was something that's sort of what this cold blood thing is, that they call it that, but the phrase just means that you spent time thinking about it and decided to do it. Well, one way that you could, there's a couple of affirmative defenses that we've all heard about to a murder claim. One would be self-defense. Why is self-defense an affirmative defense and not just like a regular defense? Because it doesn't matter if you committed the murder. If it was in self-defense, the whole thing is sort of defended against, regardless of, even if you checked every box of a murder. If that person was coming at you, you sit and you think and you go, stop, 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 stop. And you're doing it for, a minute, you back up or whatever, and you're like, I'm going to do it, stop. And then, you have technically met all the elements of a murder, but the affirmative defense of self-defense would defeat the whole thing anyway. So that's kind of the idea of it. It negates the crime or the civil cause of action, even if the prosecution or the plaintiff has proven everything they're supposed to. And what's the significance of it being an affirmative defense versus just like a regular defense? Well, the big thing that makes a big difference is that with an affirmative defense, the defense has to prove it. The defense has the burden. So when you hear burden of proof, we all, if you're talking about murder, I'm using this example because everyone watches lots of TV probably, or true crime or Law and Order or something like that. You've all heard beyond a reasonable doubt. So in a criminal case, you have to prove things beyond a reasonable doubt. Well, that goes for the prosecution. But for an affirmative defense, for self-defense, that burden shifts, not the same level of burden, but the burden shifts to the defense. And there can be different burdens. There can be something called clear and convincing evidence, which is sort of less than self-defense. There can be something called preponderance of the evidence, which just means like a slight tip in favor of the person who has the burden. So in criminal cases, you would have this self-defense would be one of the ones where the defendant would have to prove their affirmative defense of self-defense. Another example is the insanity plea. We've all heard about insanity plea. If you prove that you were mentally sort of incompetent to make the decision or whatever, and that's a lot more complex than that, but that is an affirmative defense where the defense has the burden of proving it. If the defendant doesn't push it to sort of above that burden, then they don't win. And that's kind of the big difference between the regular defense, where it's the prosecution's burden to show that for a first degree murder that you had time to think about it, that you planned it, and that you did all those other things. So I want to show you some examples of what would be affirmative defenses in a civil lawsuit. So that's not a criminal lawsuit, that's someone suing somebody else over something. And I do a lot of videos on these on like, part of why I did this video is so anyone watching like my celebrity videos or whatever, I'm doing all these like cases where I think it's helpful to like learn law, to look at real cases. This is kind of like a mini law school going on. People may not realize they're attending law school without knowing it by watching my channel, but you can learn a lot by like reading real world cases and what actually happens to people. And it's more interesting when you're looking at some YouTuber getting into a bunch of drama, or like a celebrity who did something insane or whatever than just the dry kind of cases that are in law school. So I'll show you a list, sort of what kind of defenses are affirmative defenses in civil cases, and I'm actually first going to show you an answer. So an answer is where in a civil case you would see the affirmative defenses, and I'm going to show you what they look like in the real world. Like, let's say you're looking at a lawsuit. Where would you find these affirmative defenses? Well, like, where do they come up, and how do you even see them? So this is the kind of thing that you will, at least when I went to law school, they never show you stuff like this about what is this. You'll be talking about it on and on and on, and you will never actually see it. Like, what does it actually look like when you're in a lawsuit? I remember learning about this and learning about civil procedure, and I don't think we like even saw like a real lawsuit in civil procedure, which is weird in my class. And like, and really all these cases, criminal law, you don't see like what did the paperwork actually look like? What are you actually going to do when you're a lawyer? You spend 3 years learning like theory and nothing about how to actually practice law. So part of what I'm doing in these videos is, and the reason I'm talking about this is because the people who watch this particular kind of video are much more likely, if you're this far in it, you're probably pretty interested in law. So why am I showing you this? So you can see what it actually looks like. This is from another video I did about this Brooklyn Beckham and Nicola Peltz, who had this wedding disaster where her dad, you can see that Nelson Peltz decides to sue the wedding planners or like one of, maybe it's kind of unclear, but like 6 different wedding planners that they went through, and the wedding planners responded with what we're seeing here, which is you can see it's called an answer, affirmative defenses, counterclaim, and third-party complaint. So this is a good example because they mushed in a bunch of things that usually don't all happen in one, but they're all here in this document. So you can kind of see what this would look like. And these wedding planners decided like, oh, you're going to sue me and sort of publicly knock my wedding planning abilities. Well, I'll just dump the entire wedding text chat group that we had with this celebrity wedding and show everybody everything that was happening. So I had a real long video about what happened there. Just is, if you like drama, you can go watch that one. But for the purposes of this, what are affirmative defenses? You can see this is like a document that they file. So what happens is you will the first thing that will get filed in a lawsuit is a complaint. That's the very first thing that happens in any civil lawsuit, and that's the plaintiff saying like, here's my case. Then the next thing that you could have a motion to dismiss. That's kind of the first thing that probably more often than not these days is happening because of some changes in Supreme Court law. So most defendants will try to like knock something out somehow. In California, they call them demurrer in state court, and in federal court, motion to dismiss. I'm in California now, so that's why I'm using their little phrase there for you. But this document has affirmative defenses and it has an answer. So if you don't win your motion to dismiss, you have to show up and like answer the complaint. The answer is where you go through everything that the plaintiff said. You say, that's true, that's not true, that's not true, I deny that, I admit that. You have to admit and deny everything. Most of the time, the defendants will try to deny everything possible. Then they have to raise their own. For an affirmative defense, you actually have to plead it. So you have to separately say, like, I am making this affirmative defense. Now, I won't get into the other stuff for this video, make sure it doesn't get too long, but a counterclaim is like a separate thing from an affirmative defense. That's when you are saying, okay, you sued me, well, I'm going to sue you, and it's for something else, and they come up with that. And then third-party complaint, what happened in this case is that the wedding planner decided, so like the father of the bride sues them, and they're like, you know what? Here's a little wedding present for the bride. I'm going to sue her too. And so that's a third-party complaint. A counterclaim would be against the father, Nelson Peltz, who sues here. The third-party complaint is when they sue the bride and some other people and say, I won't just sue you. I'm going to sue these totally random people who aren't even in the lawsuit right now because they're part of this mess and they're coming into it. So now let's look at the affirmative defenses that they raised here in this case, just to see some real examples of them. So here is a real world example of affirmative defenses. I think there's 19 of them. That is a lot. What you will see most defendants do, or what I've seen in most cases, is that they do what's called like shotgunning them all in. So they don't even really kind of look at whether they can win them. If there's even a theoretical chance, they dump them into the complaint. It's possible for the plaintiff to do what's called a motion to strike, which would knock those affirmative defenses out if there's no merit to them, or if they're not pled in detail. Some judges are actually like that. Some judges do not. Some judges think it's a waste of time. Some judges think you're actually saving time by narrowing the issues and by stopping defendants from just sort of like they really are supposed to put a lot of detail into these. And most defendants don't. They really are just kind of like, I'm going to just like try to make sure I can do anything I want later on. Whether that's good or bad, that just depends on whether you're on plaintiff or defense lawyer. And I'm mostly a plaintiff's lawyer, so I want that stuff knocked out. So you can see here there's a couple of these. They have this. I'm not sure this really is an affirmative defense, but they say they lump the defendants together. That's something that in Florida in particular, that the area out there, or the circuit out there, does not usually allow like grouping defendants. But it's not really a traditional affirmative defense. Here are some traditional affirmative defenses. The second one, laches, waiver, or estoppel. So I'll just use like laches as an example. Laches is a affirmative defense where even if like let's say your lawsuit is great, it went you win all the elements, you win all the proof. I ruined your wedding in this case. Laches means you waited too long. So you can you've probably heard of statute of limitations. Everybody's kind of heard of that generally, which is a specific number of years that says, if you wait 2 years, you can't win your case. Laches is kind of like that. It's like a common law defense that says you knew about a problem and you just waited too long. It doesn't necessarily have to be the statute of limitations. It usually is longer, but it's kind of a more complex way to argue the same kind of idea. Waiver would be like you did something that or waived your legal rights, even if you could win your lawsuit and do win your lawsuit, your conduct or something you said has waived your right to do it. So a lot of times that would be like, okay, like maybe I did ruin your wedding as the wedding planner, but you came up to me and said, we're done. I'm not going to do that. You could argue, I'm not going to sue you. You could argue that's a waiver of your rights. Or if you accepted, I come in with this horrible wedding cake. It's like the worst thing on the planet. And you're just like, you know what? Fine, I'll pay you and I'll take it. I got to have this wedding today, so I'm just gonna take this wedding cake. I'm fine with it. So you've accepted my wedding cake, and you could argue like, look, that act was a waiver of your rights. But these are things you'd have to prove yourself as the defendant, the burden of proof. There's a bunch of other ones in here. Some of these are specific to like Florida law. Unclean hands is an example of an affirmative defense. Like, so even though you win, like it's an argument that sort of what's called equities, which means just fairness, these principles of fairness. It's unfair for you to win, even if you win technically. Because in unclean hands, the idea is you've got dirt on your own hands. You did something wrong yourself, so you shouldn't be able to win money from me. And I don't know what they do in the wedding planner scenario, or why they're asserting it here, but that's just an argument that you can make. And sometimes there's cases where people do things like they do something real dirty. They like cheat someone, and then the other person, like, yeah, that's maybe a good example. Let's say I cheat you out of a bunch of money, and then you trespass into my house to like take the money back. Have I committed trespass, which is not just a crime, but also a tort, a way you can sue someone? Maybe I did, but you would say your hands are unclean. You stole my money. I just broke into your house to get it back. So you can't sue me for trespass because you've done this. You did me dirty first. Your hands are covered in, the blood of Lady Macbeth or whatever, something like that. See if there's any other good examples here. They have like an example here is unjust enrichment is barred by an express contract. I did another video about unjust enrichment. I'm sort of knocking out videos on legal terms that I run into that people may not know about in my crazy celebrity videos. Unjust enrichment in some states requires that there can't be a contract. If there is a contract, then that sort of blocks out this idea of unjust enrichment, which is a theory you can recover money from someone on, again, based on ideas of fairness. So if you prove there is a contract, then the contract overrides the ability to use that sort of claim. And so they have a bunch of defenses for unjust enrichment like that. The idea is maybe you prove you're entitled to this sort of tort, but if there's a contract, that your entitlement goes away, and so I'll prove there is one. And you can see, actually, it looks like a lot of that is sort of these same kind of things. And they go up to more 20 affirmative defenses, which is not uncommon to see that amount of shotgunning. So those are affirmative defenses in general. I'm going to show you one real quick, the Federal Rules of Civil Procedure, which you need to know if you're ever going to be a lawyer, and what that they have to say about this. Putting this in here mainly if there's any lawsuit students or people who kind of want to know what this is more detail, but like just so you know, in federal court, state courts have different rules of civil procedure, so they may be different. A lot of times they're modeled off the federal ones, but so federal is a good example. This is Rule 8. It is a rule of civil procedure that governs pleading, which is what you have to say in sort of the first back and forth documents that we've been talking about, the complaint, the answers, that type of stuff. So it says what you have to do, and it has rules on what you can do with your defenses and what you have to do with your defenses to preserve them. So why is everyone doing that shotgun thing we just saw? Because in this rule, and that is Rule 8C, 8C1 actually, so it says, in responding to a pleading, a party must affirmatively state any avoidance or affirmative defense, including. And so they list all the affirmative defenses, not all of them, I guess, but a lot of them. And the reason why you will see strategically defense attorneys will plead all of these in their answer is because if you don't plead anything on this list or anything that courts have held as an affirmative defense, you can see a couple ones we looked at. Let's see if we got any of them. Laches is right here. Waiver is right here. Statute of limitations is actually here. So all of these defenses, you don't prove them or plead them rather if you don't say what those people did in that answer that we just saw where they list them out. You lose it. So it's gone if you don't plead it there, and that's why they will do that shotgun, because they don't want to find out later that they learned something as part of the lawsuit and go, oh shoot, I could show duress, or oh shoot, I could show this. They put it all in at the front to preserve their rights to do it later. Now, is that really what they're supposed to be doing? Probably not, because some of these like examples are like fraud. You're supposed to plead in a lot of detail. It's called pleading with particularity. Usually they don't. Usually I don't see them do that. Usually plaintiffs' attorneys just kind of let it go because the judge may not like you trying to dismiss it. I think probably, I don't know, probably should get dismissed, because if you don't pop them on it, people will just keep doing it. But that's just a lawyer strategy, inside baseball kind of talk. And if you're trying to be a lawyer, hopefully one day you learn about it and know about it. That's what these are. You see them, and if I'm talking about them in a video, that's what I'm discussing. If you want to see either more videos about the celebrities or learn more or do this sort of YouTube law school thing I'm kind of gradually putting together over time, hit subscribe and you get more videos like this, or like the celebrity ones, or there may be some of them floating around on the end screen stuff right now, and you can hit one of those and go dive deeper into all the stuff I've been putting out here on here.